This presentation should have been made 2 years ago, but for obvious reasons, we couldn't. We don't, in fact, recognise the 24 years as a firm. That's just I did 24 years of helping. But my colleague, Caroline Bowden, started the evening clinics 26 years ago, in fact. And I think over that period, we've been to so many pubs in London, starting with Clerkenwell, Mount Pleasant, yes, that's right, Brick Lane, there was one near Brick Lane, Holborn, two in Soho, and it's been very difficult to find a venue because obviously we've been kicked out generally for not buying enough alcohol, I think. Yes. And it had to be free. So it's not been ideal by any means. And even if those are not running as regularly as they were, we've still got the online advice service, which is sort of 24/7, and my team do a rota for that. And we also have free legal advice, 20-minute sort of sessions on Eventbrite. So if you wanted to access legal advice away from that sort of evening pub setting, then if you visit our website, you should be able to find something like that. So thank you very much for this. It's really incredibly flattering. I'm very grateful. With the conference pack, I've put something out on fact-finding hearings. And again, I was going to speak about this 2 years ago, and the landscape was totally different then. I was doing fact-finding hearings on a monthly basis at great expense to both parents, both emotionally and financially, because these hearings are rarely less than 3 or 4 days, and I have had one that was 10 days. But in the space of the 2 years of the pandemic, it's become even more relevant that I'm here today talking about something quite different that I think should welcome you. I hope I'm sort of speaking with, not assuming too much knowledge, but a fact-finding hearing is the first limb of a split hearing. So it's a hearing divided into 2 parts, and the first half, the court makes findings of fact where there have been allegations of abuse, and those allegations are recorded on something called a Scott schedule. Anybody who wants to know what that looks like or would like a template, just email me and I'll send you one. Then after the findings have been made, there's a second hearing when child arrangements are dealt with. And there were lots of those 2 years ago, and I imagine that something behind the case I'm going to briefly talk about is to do with the fact that the courts cannot cope with this. Quite apart from the toxic effect it has on parents, and allegations that cannot be unsaid, the courts cannot give time to these hearings in the way that they've had to. And so the big case of the moment is K versus K. It's a Court of Appeal decision, so we must heed it. And the Court of Appeal have made it plain that you don't have to have a fact-finding hearing. It's only when the allegations will have a direct bearing on the child's welfare that there will be a fact-finding hearing. And you may know when you make an application for a child arrangements order, you file something called C100. Sometimes you file that with C1A, which is when you're alleging harm. But all too often, these allegations of abuse are not even raised at those stages. They come out in conversations with the Kafka safeguarding officer, conversations which probably last no more than 15 minutes, 30 minutes. And that conversation with fresh allegations of abuse that were never raised at the beginning leads and feeds into the court process and the fact-finding hearing and the decision to hold one. But the case of K&K says, no, that's not necessary. It's actually damaging, and it's only going to be relevant to hold a fact-finding hearing when you know that that's going to have an impact on the child arrangements. Now, that's not to say that we're not going to have fact-finding hearings. The buzzword at the moment is coercive and controlling behaviour, The police are taking that seriously, and lawyers are too. And those are the lengthy fact-finding hearings, because it's layers and layers of allegation, not just punchy 5 examples. So we will still have them, and that's why I invite you, if you want to know what a Scott schedule would look like, either in relation to that kind of allegation or the more traditional reason why we had fact findings, then just email me. And I think the good thing about narrowing down fact-finding hearings is that orders for costs are made in these hearings. That's not usual in Children Act proceedings. But in fact-finding hearings, it's quite common that the person who has allegations which are made against him or her will pay the costs of that, and it's catastrophic. The costs are exorbitant. Slightly off point, but I think it's an important case, and it's one that's been published recently called Re-P. And it's also before the Court of Appeal. It involved allegations of rape made by a mother against a father. And the civil burden of proof for criminality is the balance of probabilities. And the criminal burden of proof, as you'd expect, is higher. It's beyond reasonable doubt. So it's very, very frightening to have a fact-finding hearing in a family civil court with a lower burden of proof when the allegations that are being tested could then lead to criminal prosecution. So the P case was a father appealing against a decision in the family court to the Court of Appeal, asking for statements and the evidence that was given on the fact-finding hearings not to be produced in any later criminal hearings. And the Court of Appeal found against him and said anything that came out in the civil hearing, family hearing, would be produced to the police when they make, via the CPS, a decision whether to charge in the criminal proceedings. And it's a frightening thing, that, because obviously being prosecuted for a criminal offence can be the gateway to legal aid and criminal legal advice. Dealing with fact-finding where criminal allegations are raised in the family court, possibly as a litigant in person, but certainly without any funding for criminal legal advice, is, I just want you to be aware of it. I mean, if anyone with money, and I don't say it lightly or make any assumptions that people do have money for this, but anyone with money would be well advised to take some criminal advice if criminal allegations are raised in the family court leading to fact-finding. Because the family courts at Court of Appeal level have made it plain that they don't accept that there's a right to silence in that court. And you can imagine if you did exercise a right to silence, that could then impact on your relationship with your child and the ultimate order that would be made. And then finally, again, moving completely off-piste, we heard this morning about the challenges to mental health caused by these proceedings and any severance of a relationship with a child, and that one of the big stressors is the ongoing contact with an ex-partner. Could you tell me if any of you have heard of an app called Our Family Wizard? Yeah, so that seems quite a few of you. So this is really a plug for those who have not heard of it, because it seems to me that this is an excellent app for reducing and defining communication between parents in a way that's not redactable and can easily feed into ongoing family proceedings. It's got features that are helpful in any case: calendar, journal, opportunity to store information about GP, inoculations, vaccinations, school holidays, expenses, a method of attaching receipts to expenses, what else? Message board, sharing of photographs. But most importantly, it's not something that can lead to miscommunication because it's out there and it can't be amended or deleted. And it can be downloaded quite simply as an attachment to a statement in proceedings. And because it's for a specific purpose, there's less opportunity for parents to abuse communication when they have this method of doing so. And hopefully it would lead to more normal communication as time goes by. I wondered if it was something that actually FNF might be able to use financially, because there is a bulk buy for the app, and I think there's even some kind of commission arrangement that the business are prepared to entertain. So, you know, it might be something that you could use as an organisation. I'm not on commission, by the way. Now, I've spotted one lawyer and mediator in the audience, William Hogg. There might be more than one? No? You? Right, well, there are 4 of us. And I kind of hope that we can share the questions then, because I've found in previous years that lots of people do have questions. So I won't continue talking about fact-finding, which is in the conference pack, and happy to sort of hand over for questions if that suits you.
Yeah. Tom.
Hi, I've got a question actually. Yeah. Sorry, about that particular case. What was the date of that case that it came? Was it recent? The Court of Appeal.
The P one about the one criminality, about, or the K one?
The one about where the Court of Appeal said that any evidence they find in the finding of fact can be used. Because surely then a father would or should be very careful about what they say in the finding of fact and say it may prejudice any outcome of any criminal investigation at every point, because when you go into a police office an interview, you can deny stuff. You have the right to silence. If you blab and you're expected to blab a finding of fact, everything you say can be used against you. So it's an absolute contradiction. So what date was that? Was that recent?
It was within the last month.
Within the last month.
Yeah.
So that's, I mean, and in practice, my understanding is in findings of fact are sometimes, even though officially they're not needed unless it affects the child, sometimes judges just say, well, we're going to have one anyway. They do in the reality
they have, but obviously the K case
might change
is also the last month.
Right.
Might change it, and I think at the Court of Appeal level it should change it, yes.
Okay. I guess my question is, or my advice, if it were my situation, would be really, really careful then as to what you're going to say, if anything, at any finding of fact. Yeah,
but of course, the silence in the family court could then invite guilt.
It could infer,
and of course, your aim in that court is to see your child.
Yes.
I don't have any answers. I just wanted to flag it up.
Yeah, absolutely.
Yeah.
I'm sure it remains to be seen, but I wonder how helpful you think K and K will actually be, given that what it really does is simply reinforce Practice Direction 12J and the requirements that what the court should be looking at in its decision as to whether a fact-finding hearing is necessary and proportionate is the extent to which any allegations, if true, would influence the court's decision on child arrangements, which is always going to be a matter of interpretation anyway, and I just don't have confidence that it will really result in a more careful consideration by the courts, in particular magistrates who, in my experience, are very, very procedural in their approach, and in relation to any allegations at all without proper consideration as to their relevance in relation, whether they just relate to the altercations between the couple or whether they will impact on child arrangements, will simply just almost automatically order fact-finding hearings now, which I consider massively damaging, both in terms of the delay and cranking up the acrimony between couples. And I think the advent of split hearings over the last decade has been a really damaging development.
Well, I totally agree with you, but obviously magistrates should not be ignoring the Court of Appeal, and the legal advisors who are representing parents before them will be talking about this. I mean, I think what the Court of Appeal says is you can get this evidence in other ways without this added, hugely expensive layer. You can have statements, you can have witness evidence, you can have medical evidence anyway, without this sort of extra layer, which we never used to have in past years.
Yeah, hello. So, bit of an odd question. I mean, the impression I have is if we don't have fact-finding hearings, then what? You know, it feels like we're in a limbo state, you know, where the allegations may be true or maybe not true. So, what's your view?
I think I'm sort of with the Court of Appeal that that if these allegations are going to be made out, then why not make them out in the way we used to in the olden days, 5 years ago? And, you know, they would be contained in statements and witness evidence and so on, and it would be dealt with in that way, without an extra 4-day hearing. I even think the magistrates are going to go with this because we don't have the resources. It may simply be a resource issue. We do not have the resources to have hearings of 3 to 4 days bolted onto Children Act proceedings. So I think most courts are going to be quite happy to follow the guidance.
Just following on from the gentleman's point, my experience certainly of CAFCAS recommendations and social service intervention is to assume that the allegations are true unless there has been a hearing that says that they're unproven. And so I see far more risk to fathers from not having a fact-finding opportunity or an opportunity to rebut the allegations put against them than having that opportunity, even if they're litigants in person, at least having the opportunity to say, no, that's not true, here's my evidence, why not? And I know you're saying that that it'll come into place, but the only place that it gets heard is at the final hearing, and that's the recommendation from CAFCAS has already been put in at that stage. So, you know, I can see nothing but risk arising from this development for men. The second point was, the question was, did the court actually indicate in the K&K case any threshold indications for deciding?
No. And they didn't give guidance about how you would measure whether the allegations would link up with the welfare of the child. They simply referred back to another case, which is, first of all, they referred to the practice direction and said follow it to the letter, and then they referred to the case of H&N, which was a case of end of last year, and said that case had got it right. There's quite a lot more guidance in H&N than there was in K. So it is worth reading the two cases together if you're embroiled in that kind of world.
Thank you. Andrew McFarlane put out some guidance on fact-finding on the 5th of May. Yeah. Does that create opportunities as well as challenges from a father's perspective in your view? And the second part of the question is, a lot of fathers seem to be on the defensive, and seeing that coercive control and child alienation is a form of domestic abuse, should that not create a positive opportunity for the fathers to go on the front foot and hold the mothers to account for the way they've acted in the intervening period?
Yeah, the guidance you're referring to is the guidance from Andrew McFarlane, which will go out to all the courts. And it sort of is a condensed version of the Court of Appeal's guidance in K&K. And I think because it's come from the top, it will lead to fewer fact-finding hearings, even at magistrates' level. It's inevitable that it will. You're saying, should fathers be on the front foot and go for fact-finding on the basis that... yes, in the sense that mothers do that as well. Well, I mean, if fact-finding is going to be something that's not the way to present the evidence, you're not precluded from presenting those allegations either in your dealings with CAFCAS or in your C100 or in your C1A or in any statements that you file. It's just you won't be presenting them in a Scott schedule form, which actually is not a very great format for coercive control anyway.
Hello, it's Wade Martin. And with Vincent getting my household cavalry earlier life sorted. I'm also a 20-year ex-police officer. So not so much to finding a fact, but false allegations of what you've done. But when access is denied and you put your C100 in, that's an actual coercive and controlling behaviour. You're being denied access to your children. So that is a fact. That is never brought in. Secondly, when you get a court order and contact is denied, you try and take it back for enforcement, 0.01% success rate. Why can't you take it straight back? Would you suggest fathers could take it, or parents with denied access, go straight to the police, coercive controlling behaviour, denial of access, and it depends whether you're still in a intimate relationship or living together, whether the coercive controlling legislation is active, or protection from harassment. It's one or the other. And it's a different route, the criminal route to take, to put pressure on contact to go ahead, rather than try and take it back. And that's the same way as if the two parents meet and one slap the other. It wouldn't go back to family court, that would go into the criminal court. So can we use this legislation through a different route to get better outcomes? An opinion, please.
I suppose I don't know the answer to how seriously the police would deal with that kind of scenario, and I suspect not. I suspect my answer would be that if a child arrangement order is being breached, that maybe the enforcement route is not the most obvious, and going straight back to court to change it. Possibly changing with whom the child resides, if there are perpetual breaches.
I have an answer a little bit to that. Yeah. Wouldn't it also, isn't it contradictory? Because if you did do that, the social worker would say you're causing acrimony and therefore you're affecting the emotional health of the child because you've gone to the police. So it literally goes round in circles. It can be used either way, right? I don't know. I
think it would be a dangerous thing to do.
Yeah.
Good morning. Just like some clarity, please, because I occupy the space which you just spoke about, where a false allegation of rape has been brought into my case, which the penny also just dropped now, is to further get legal aid. So can you just clarify what sort of advice I should be seeking, because I'm a litigating person, reference the upcoming fact-finding?
So the fact-finding, it involves an allegation of rape?
That's right, yes. Would it be, because you get a state or sponsored solicitor to sort of guide you, would that be the person giving advice, or a totally separate family lawyer, because I am a lip?
I think if money were no object, and it clearly is, then I would probably take an advice from a criminal lawyer at this stage, because the problem with the finding being made is that it could then lead to, through your former partner, could then lead to a complaint to the police.
But there is already.
It's already, it's running in parallel,
That's right, yeah.
The investigation, right? Yeah, as it would often be, not always. But then I think that your primary concern would be to take advice from a criminal lawyer, if that were possible.